Under the Constitution's Sixth Amendment, everyone has the right to a fair trial. Defined under a fair trial is the right to adequately defend yourself against any charges posed against you. What that means is that the accused has to understand the nature of the proceedings against them, the fact that they're in court, there's a judge, there's been an accusation, there's a prosecutor, they're represented by an attorney, they have some understanding of the nature of the proceedings, and that the accused can assist the attorney in the defense. If at any time the lawyer thinks that their client may not be all there, or doesn't understand what's going on, they actually have the duty to go before the judge and say, Your Honor, I'm declaring a doubt. And what that means is that the lawyer now has a doubt in his or her mind that their client can either understand what's going on or adequately assist in the defense. It's a constitutional fundamental right that someone has to understand what's going on. So what happens is the defense attorney raises the doubt, the prosecutor cannot, and the judge can on his or her own, but overwhelmingly it's the defense attorney by talking to the client. Usually they're in custody, so you went and you spoke to them, and right away you can tell something's not right, and you bring it to the attention of the judge. Now, the rule is you have to show substantial evidence to the judge regarding a doubt in the competency, but that's normally satisfied by just saying, Your Honor, I just spoke with my client, and he told me that it's always Wednesday on Mars. That would suffice. I spoke with my client. He doesn't understand the charges against him. That could suffice. Your Honor, I spoke with my client and there's just no ability to communicate between each other, and there's no language barrier. So all of this the judge has to interpret, and a lot of times the judges err on side of caution here. They don't want to risk appeal. They don't want to risk reversal. And so what they'll do is it's basically one giant timeout in the criminal proceedings. The judge suspends criminal proceedings. Usually, every time I've ever seen it as a DA or a defense attorney, the person's in custody. It's usually on some serious felony counts. So the judge calls a timeout, and she or he transfers the case to mental health court. And there you have specially trained and experienced judges and lawyers and experts. That's really the big thing. What happens when you declare a doubt is an expert, a psychiatrist or a psychologist will be appointed by the court, and they'll meet with the client. A lot of times you ask them not to talk about the facts of the case, but then they make a report and kind of a diagnosis. If it takes more experts, so be it. And then it will go to the judge and there will be a determination. Now, it does get technical. You can actually demand a jury trial on competency. I've never seen it done before, but usually you leave it up to the judge. And if the judge does find that the accused is not competent, then that person usually remains in custody. Often they're transferred to a mental health hospital where they will receive treatment until they are deemed competent. This happened in the Colorado shooting at the movie theater. He was later deemed competent, and I believe he's getting ready to stand trial. So it's not any type of dismissal of the case. It doesn't get them off, but it gets them really medicated is usually the ideal situation. And a lot of times you can use that for the defense in terms of if they weren't properly medicated before and now they are properly medicated, it helps to go to the prosecution and say, listen, this crime may have happened because he wasn't properly medicated. He's also accruing credits for the time in custody. But really the heart of competency to stand trial is a safeguard so that we don't have mentally challenged defendants on trial and getting in a lot of trouble and receiving heavy punishments without them understanding the nature of why that is happening.